Hey everyone, it's Rob Ryder. Um, if you know a canonist, please ask him to watch this video. My email address, of course, is quarterrecordaol.com. 616-712-6179 is my phone number, and it's the 25th day of September in the year of our Lord 2012. And according to Webster's 1828, a canonist is a professor of canon law, one skilled in the study and practice of ecclesiastic law. See how much they know. So a doctor of canon law, doctorate level in the studies of canon law of the Roman Catholic Church. And as you can see, they got different, these attorneys like their additions, don't they? So you got an ICD, ICDR, DCL, DDC. But the doctors of both laws, canon and civil, are JUDs. I want to find me a JUD or UJD. Take your pick. Well, it's nice to meet you. I'm Robert Allen, SOG. That stands for Son of God. And I accept your oath, vow, or promise, bind you to it, remind you of your duty to the faithful. I'm not looking for marriage counseling. I'm looking for justice. So what do they look like? Well, they look something like this. Here's a site you might want to write down if you're not a canonist. canonlaw.info. And take you to this site here. And, for one reason is if you want to see what canon law is, here's the 1983 code in English. And this guy's a Dr. Edward Peters, an American lay canon lawyer. He teaches, writes, speaks, provides consultation and advocacy. Okay. Well, I don't see any horns on him. Looks like a nice guy to me. So's John Paul. I wonder if we've been led to believe things aren't really the way they are. But what anything, what's this guy say about a canon lawyer? Forget the rest. Let's go to the bottom. Keep in mind, canon lawyers are not moral police or oracles of spiritual wisdom, and they are not perfectionists who enjoy clogging the gears of church government. Their sole task is to protect every Catholic's rights, and to explain every Catholic's duties. We have a lot of people explaining our duties, but hardly anybody ever tells us what our rights are. Well, all this stuff is written in canon law, so let's go take a look at it and see what it has to say. Canon 18 or 849, baptism, the gateway to sacraments, is necessary for salvation, either by actual reception or at least by desire. By it people are freed from sins and born again and as children of God and made like to Christ by an indelible character and are incorporated into the church. It is validly conferred only by the washing in real water with the proper form of words. Okay, so if you're baptized, you've been freed of sins, and now you are incorporated into the church. Well, the church has its own inherent right to constrain with penal sanctions Christ's faithful who commit offenses. So, I'm not interested in charging a priest, an ordained minister. No. I got some problems with some of Christ's faithful. And you have jurisdiction over it. Canon 204, Christ's faithful are those who, since they are incorporated into Christ through baptism, are constituted the people of God. For this reason, they participate in their own way in the priestly, prophetic, and kingly office of Christ. Did you get that, canonist? Right? That means me. My brothers and sisters, baptized, constitute the people of God, and for this reason participate in their own way in the priestly, prophetic, and kingly office of Christ. We, the faithful, the laity, are the high priests of Christendom, competent to hold the office of king of our domain, in the image of Christ, and you are our court officers, commanded to see that justice is done. We, the people of God, demand swift justice. Now, this is out of the New Advent Catholic Encyclopedia under Administrator. Very, very, very interesting stuff, but we're going to go to just this short part. But while the abstract right of the church and the representative and her representatives to hold property is clear enough, there has been in past ages much vagueness and diversity of the view of precise subject to whom right was vested. The idea of corporate body as that of an organized group of men which has rights and duties other than rights and duties of all or any of its members existed, no doubt, at least obscurely, in the early centuries of the Roman Empire. Before the time of Justinian, it was pretty clearly apprehended that the members of such group formed legally but a single unit, and it might be regarded as a fictitious person. Though this conception of persona ficta, dear to the medieval legist and perpetuated by men like Savigny, is not perhaps quite so much in vogue among modern students of Roman law. Yeah, they think we're each separately a fictitious person, where it's quite clear by canon law that we form a single person, one single unit. We're each a part of Christ, and you're supposed to protect us. It was at any rate recognized that a fictitious person or group person was not subject to death like individuals, of which it was composed, and on the other hand, it could not be called into existence by private agreement. Your all-capital name is a fictitious person. It's the name of a landed estate, and it contains all of our property from inheritance from the Creator. It's all part of the birth registration system, which we're not going to go into now, but can't be called into existence by a private agreement. Then why am I getting sued from a civil court in my all-capital letter name? It is contempt of court to sue in the name of a fictitious plaintiff. A bank can't sue a living man. Neither can an all-capital letter attorney. That's a corporation. It cannot be called into existence by private agreement. It required senatus conciliatum, or something of the sort, to be legally constituted. These well-understood principles, as we might suppose, could easily have been invoked to regulate the ownership of property in the case of the Christian communities established in the Roman Empire, but the question, in point of fact, was complicated by the survival of the ideas which attached to what is called res sacri in the old days of paganism. This title, sacred things, was given to all property or utensils consecrated to the gods, though it was required that it should be some authoritative recognition of such consecration. We're each a sacred thing. We've been consecrated to God. However, there hasn't been an authoritative recognition of the consecration yet. Now, an interesting thing happened last Friday. A brother out in Utah, he walked into the local diocese, and after a conversation with me, I said, well, go in and ask for the judge of first instance. And he did. And he got past the counter trolls who didn't want to pay any attention to his paperwork. He was merely trying to get the church seal on his document to say that he was a living man. It had already had a notary put on it. It had already had the seal of a court of record put on it. And the counter troll said, well, we don't have jurisdiction over civil matters. Well, shame on you. First of all, there are no civil matters. We'll get into that later. Anyways, he went back in, and this time he got to see the judge of first instance. Got to walk past into the inner sanctum, past the counter trolls. Had a little conversation. Now, he didn't really know what all to ask, but one of the things that he found out when he showed this document, which was really the notice of judgment I had done some time ago, made into his own words, with these seals on it, the judge of first instance said, well, there's really nothing we can do. This is a civil document, but I can see from looking at it that you've given plenty of evidence that you're a living man. Well, what Mike didn't know what to ask is, well, then, how come I can't get justice? But what he did find out is if you were to take your certificate of live birth to the church would put their seal on it. I think that's the consecration we're talking about right here. So, consecration. The church distinguishes consecration from blessing, both in regard to persons and to things. Hence, the Roman pontifical treats the consecration of a bishop and the blessing of an abbot, of blessings of a cornerstone, and the consecration of church or altar. In both, the persons or things pass from a common or profane order to a new state and become subject of the instrument of divine protection. That's why you want to get your certificate of live birth, to have the church seal on it. You'll have divine protection. We just need to get it recorded in the office of the recorder, which happens to be the chancellor, the bishop. He's the office of the recorder. He is the recorder. He's the highest judge in the district. Or we can call it a diocese. At a consecration, the ceremonies are more solemn and elaborate than blessings. The ordinary minister of a consecration is a bishop, while the ordinary minister of a blessing is a priest. So the bishop has to consecrate your paperwork, and he does that by putting his great seal on it. At every consecration, the holy oils are used. At the blessings, customarily holy water. The new state to which consecration elevates persons or things is permanent, and the rite can never be repeated, which is not the case of a blessing. The graces attached to consecration are more numerous and efficacious than those attached to blessings. The profanation of a consecrated person or thing carries with it a new species of sin, namely sacrilege. With the profanation of a blessed person or things does not always do so. Profanation, I guess. So, profane. Once you get consecrated, they can't talk to you. They can't touch anymore. If you're just blessed, if you've been baptized and blessed by a priest, yeah, that's good. Ain't quite enough. You need to get the bishop to consecrate you. The Pope's power in this consecration is solely administrative. In this connection, okay, now we're back to the property. I had to throw that in, New Advent, but now we're back to administration of ecclesiastic property. The Pope's power in this connection is solely administrative, as he cannot be said properly to be the owner of the goods belonging to either the universal church or to the particular churches. We're each a church. I don't have separation of church and state. We're each a church. In these dioceses, the administration of property belongs primarily to the bishop, subject to the superior authority of the Holy See. From the very beginning of the life of the church, this power has been part of an episcopal office. The bishop is in charge of all diocese property. So, if you're a member of the society, he's administering your estate. On him, all inferior administrators depend, unless they have secured an exemption by law, as in the case of religious orders. Therefore, if an agreement exists by which the administration of certain diocesan or parish property is entrusted to some members of the clergy or to laymen, the discipline of the church nevertheless maintains the bishop in supreme control, with the right to direct and modify, if need be, the action taken by subordinate administrators. Well, right now our shit's being administrated by the county, by a court called the probate court. And they're not doing it in good faith. In many places, laymen are called to a part in the care of the church property. Okay. Lay administrators remain completely subject to the bishop, in the same manner as the parish priest. The difficulties caused by illegal pretensions of trustees in the United States during the early part of the last century evoked from the Holy See a reiteration of the doctrine of the Church regarding diocesan and parish administration, notably in a brief of Gregory, with a bunch of Roman numerals behind him, wherein the Pope declared anew that the right of such inferior administrators depends entirely on the authority of the bishop, and that they can do only what the bishop has empowered them to do. What'd you tell them they could do, Bishop? Judge of first instance? Because I think they're going beyond their mandate. In some dioceses where the system of administration by lay trustee is in vogue, like all the United States of America, the regulations of the discipline of the Catholic Church are made part of the bylaws of the church corporations, a measure which is of great advantage in case of a process before the secular courts. The discipline of the Catholic Church are made part of the bylaws of church corporations. They're all church corporations. Everything is an ecclesiastic corporation. Please take the name of your favorite court and go look on Manta. Right? Your favorite civil court, whatever circuit court is, whatever. You're going to find that it's a private business. It's not a court. It's a private court. It's not a civil court. It's a frickin' private court. The administration of property belonging to religious institutes under the jurisdiction of the ordinary rests naturally with their superiors, but the bishop may reserve to himself in the constitutions a large right of control and supervision. Well, let's get out the contract to see what you got us into. Canon 219, all Christ faithful have the right to immunity from any kind of coercion in choosing a state of life. Yet, we are enslaved as U.S. citizens in an ecclesiastic society that practices separation of church and state, whose leaders pray to an owl in Bohemian Grove in California. Frickin' go Google it. Right? All them bastards in D.C. in August go out to Bohemian Grove. They got a 40-foot tall owl and they frickin' pray to it. They put on their cloaks, fraternity warb, what they wear in their fraternity, and they walk around spanking each other's ass and praying to a fucking owl. Excuse me, Lord. Excuse my French. Canon 220. No one may unlawfully harm the good reputation which a person enjoys or violate the right of every person to protect his or her privacy. Yet our homes are invaded daily by those who do not fear God, in a private court system that does not recognize God, nor his justice. Canon 221, Christ faithful may lawfully vindicate and defend their rights they enjoy in the church before the competent ecclesiastic forum in accordance with the law. I'm not coming looking for frickin' marriage counseling. I'm looking for justice. We the faithful, the laity, the high priest of the kingdom of heaven demand our justices speak our law and defend our realm. If any members of Christ faithful are summoned to trial by the competent authority, they have the right to be judged according to the provisions of law, to be applied with equity. We are summoned to by private individuals using complaints not under notary seal and summonses not under the seal of a justice. However, these instruments, these summonses, are under the seal of a clerk of the court, and that's an ecclesiastic office giving our courts, the universal church of Jesus Christ, jurisdiction to ensure justice is done. If it's got a frickin' notary seal, clerk seal, anything on it, it just became the jurisdiction of the church. It's a matter of faith. Christ faithful have the right that no canonical penalties will be inflicted on them except in accordance with the law. Anyone convicted of a falsehood, such as false IRS filings, is being charged with perjury, an ecclesiastic offense, a sin. Yet the proceedings are done using color law, coercion, simony, false witness, lying, adulteration of one's God-given character, subject to the penal code. In other words, canonical penalties not in accordance with law. Canonist, where is the justice? They are also obliged to promote social justice and mindful of the Lord's precept to help the poor from their own resources. To promote social justice, we now bring our petitions to the court of Jesus Christ, following his example and pointing out these transgressions of God's law. These are easy to spot, but justice has been impossible to find. Canon 223, in exercising their rights, Christ faithful, both individually and in associations, must take account of the common good of the church as well as rights of others and their own duties to others. Canonist, your conscience is now called before the Creator. You are, for the good of the church, going to show yourselves and fulfill the duties of your office. Protect the weak and poor from the rich and powerful. See to it that the wrongs are righted. Ecclesiastic authority is entitled to regulate, in view of common good, the exercise of rights which are proper to Christ's faithful. Well, if the ecclesiastic authority believes it can regulate my God-given rights, then I believe I can mark them as a heretic if they do not fulfill the functions of their office. We are not coming for marriage counseling. We are coming for justice. Canon 227, the lay members of Christ's faithful, belongs the right to have acknowledged as theirs that freedom in secular affairs which is common to all citizens. In using this freedom, however, they are to ensure that their actions are permeated with the spirit of the gospel. In other words, good faith. And they are to heed the teaching of the church proposed by the magisterium. But they must be on guard in questions of opinion against proposing their own view as the teachings of the church. We, the faithful, determine to live in peace, honor the Heavenly Father, and treat our brothers like ourselves, are of the opinion that the magisterium released to us the hidden knowledge so we can better serve our brothers and sisters by healing the sick, helping the poor, using our God-given energy to restore the kingdom of heaven here on earth. Quit hiding the information. Canon 229, lay people have the duty and the right to acquire the knowledge of Christian teaching, which is appropriate to each one's capacity and condition, so that they may be able to live accordance to the teaching, to proclaim it, and if necessary to defend it, and may be capable of playing their part in the exercise of the apostolate. Excellent. I'm going to point out the defects in the law. I need a canonist to adjudicate it. I need the judge of first instance to render a decision. They also have rights to acquire the fuller knowledge of the sacred sciences, which is taught in ecclesiastic universities or faculties or in institutes of religious science, attending lectures there and acquiring academic degrees. It says I have the right. It doesn't say I have to pay for it. It's a frickin' right, and I demand the right. Likewise, assuming that the provisions concerning the requisite suitability have been observed, they are capable of receiving from the lawful ecclesiastic authority a mandate to teach the sacred sciences. Yes, I want to teach the sacred sciences. I want to teach my brothers and sisters how to make free energy, because everything is known. There's nothing new under the sun, and I want a mandate to do it. Canon 11, merely ecclesiastic laws bind those who were baptized in the Catholic Church. And again, Catholic Church is the universal church of Jesus Christ, or received into it, who have sufficient use of reason, unless the law expressly provides otherwise, who have completed their 7th year of age. The judge of the first instance presides over the tribunal, that is to hear our petitions for justice. This tribunal has exclusive jurisdictions in matter of faith, sin, that'd be transgressions of God's law, oaths, contracts, crimes, instruments under notary seal, usury, perjury, etc. There is no civil government, as those we consider public officials have not taken the oath prescribed in the Constitution to hold a public office. What they have taken is a promissory oath sworn to God, a solemn contract under seal, and they are operating in bad faith. For instance, per 12 U.S.C. 73, bankers swear an oath to good faith and not to violate the National Banking Act. This act says mortgages can only last 5 years, with a 5-year extension. The same with UCC 1 liens, and these liens must be recorded. A deed of trust or other instrument that convey an interest in property, real or personal, is by definition a security instrument. It is not the lien. A deed of trust is not the lien. It's a security instrument. If the lien has not been recorded, the deed of trust is a false obligation. False obligation. That just put it in ecclesiastic jurisdiction and in the jurisdiction of the ecclesiastic court. If the bank has not acknowledged the deed of trust, they are in breach of contract, as both parties must agree, sign the contract, deed of trust, and the bank is not. It's what the law says, people. Canon 381. In the diocese entrusted to his care, the diocesan bishop has all the ordinary, proper, and immediate power required for the exercise of his pastoral office. He's supposed to be here as an apostle, except in those matters which law or decree of the Supreme Pontiff reserves to the Supreme or to some other ecclesiastic authority. Those who are at the head of other communities of faithful mentioned in Canon 368 are equivalent in law to a diocesan bishop, unless the contrary is clear from the nature of things or from the provisions of the law. So you don't need to be a Roman Catholic. If you're a Methodist, whatever your religion is, there's somebody who has the same power as a bishop. And you may actually have your own canon laws, but they're not going to violate these canon laws, because all canon law came from the Pope, from his council. Canon 368, particular churches, in which and from which the one and only Catholic Church exists, are principally dioceses. Unless the contrary is clear, the following are equivalent to a diocese: a territorial prelature, a territorial abbacy, a vicariate apostolic, a prefecture apostolic, and a permanently established apostolic administration. If it's got an apostolic in it, it is a particular church, falls under the jurisdiction of the Universal Church of Jesus Christ, the Catholic Church, under canon law, and we want justice. Mindful that he is bound to give an example of holiness, charity, humility, simplicity of life, the diocesan bishop is to seek in every way to promote holiness of Christ's faithful according to the special vocation of each. Since he is the principal dispenser of the mysteries of God, he is to strive constantly that Christ's faithful, entrusted to his care, may grow in grace through the celebration of the sacraments, and may know and live the Paschal mystery. Okay, bishop, judge of first instance, excuse me. Time to get busy. The diocesan bishop governs the particular church entrusted to him with legislative, executive, and judicial power in accordance with the law. The bishop exercises legislative power himself. He exercises executive power either personally or through vicar general or the episcopal vicars in accordance with the law. He exercises judicial power with either personally or through judicial vicar and judges in accordance with the law. He can either do it all himself or he can appoint somebody else to help him. He can determine the law and give the remedy. He can do a summary proceeding. If I bring in the evidence and it's crystal clear that a bank has not acted in good faith, I don't expect it to go to a long-ass court hearing. I expect to have almost instantaneous remedy. Since the bishop must defend the unity of the universal church, he is bound to foster the discipline which common to the whole church, and so press for observance of all ecclesiastic laws. Well, they ain't following them laws. They don't fear God. So they don't mind taking an oath because they think their sins will be forgiven on their deathbed. I don't think it works that way. I think it takes good faith. It takes faith and good works to get in the kingdom of heaven. Faith alone is not enough. In each curia, a chancellor is to be appointed, whose principal office, unless particular law states otherwise, is to ensure that the acts of the curia are drawn up and dispatched, and that they are kept safe in the archive of the curia. He's the secretary. It is considered necessary. If it is considered necessary, the chancellor may be given an assistant who is to be called the vice-chancellor. The chancellor and vice-chancellor are automatically notaries and secretaries of the curia. Oh, look at that, notaries, an ecclesiastic office. Public notary, chancellor, vice-chancellor, clerk of the court, registrar, they're all notaries. They put their seal on it, church just got jurisdiction. Canon 747. It is the obligation and inherent right of the church, independent of any human authority, to preach the gospel to all people, using for this purpose even its own means of social communication. For it is to the church that Christ the Lord entrusted the deposit of faith. So the faith's on deposit, so that by the assistance of the Holy Spirit it might conscientiously guard revealed truth, more intimately penetrate it, and faithfully proclaim and expound it. Okay, I've come to collect my deposit of faith, my grace, my inheritance from the Creator. Our bodies are land. They've been registered as such. From that land, a smaller estate was carved. For someone like myself, a man, it could have been your foreskin. It's probably stapled to a piece of paper right now, made my landed estate. It was a clump of dirt given in livery accession to a tenant, a farmer, to farm the field. And the frickin' farmer owes me rent. The church has the right always and everywhere to proclaim moral principles, even in respect of the social order, and to make judgments about human matter insofar as this is required by the fundamental human rights or the salvation of souls. Human rights and salvations of souls, man. Canon 748. All are bound to seek the truth in matters which concern God and His church. When they have found it, then by divine law they are bound, and they have the right to embrace and keep it. I have found the world to be a corpse, and such a world is not worthy of such a man. Gospel of Thomas. Canon 751. Heresy is an abstinent denial or doubt after baptism of a truth which must be believed by divine and Catholic faith. Apostasy is the total repudiation of the Christian faith. Schism is the withdrawal or submission to the Supreme Pontiff or from communion with the members of the church subject to him. Withdrawal of submission to the Supreme Pontiff. Okay, well, what did Blackstone's Commentaries of English of the Laws of England by William Blackstone, Book 4, Chapter 4, of Offenses against Church and Religion. I shall not perplex this detail with the various repeals and revivals, these sanguinary laws in the two preceding reigns, but shall proceed directly to the reign of Queen Elizabeth, when the Reformation was finally established with temper and decency, unsullied with party rancor or personal caprice and resentment. And so by Statute 1 Elizabeth C1, all former statutes pertaining to heresy are repealed, which leaves the jurisdiction of heresy as it stood at common law. As to the affliction of common censures in the ecclesiastic courts, and in the case of burning the heretic, in the provisional synod only. Synod, however you guys say that, synod. So only the provincial synod, which is I'm going to say that's the metropolitan, only he can burn him at the stake. So where does this power come from in ecclesiastic courts? In case we need to take some heretics there, if they don't change their ways real quick. Judicial power in the church. In instituting the church as a perfect society and distinct from the civil power and entirely independent of it, Christ gave her legislative, judicial, and executive power to be exercised over her members without any interference on the part of civil society. I don't have to have a damn thing to do with their civil society. I'm incorporated into the church, a perfect society. The term church is a name employed by the Teutonic language to render the term by which the New Testament writers denote the society founded by our Lord Jesus Christ. That is what the church is. It's a society, a perfect society. And I'm a member, and I have nothing to do with the civil society. The civil society is old Roman law, pagan law, says that you can still have slaves. Same in Jewish law. They didn't see Christ as their redeemer, so they're still following Moses' law. And in Moses' law, you can have slaves. I'm not part of those. If one admits the divine institution of the church and the authenticity and authority of the Gospels, he must acknowledge that Christ so constituted his church as to enable her rulers to make laws and regulations for the faithful, conducive to the attainment of eternal happiness. The church has jurisdiction over the faithful. Now, the infliction of punishment certainly presupposes evidence of a crime, since according to natural law, no one can be condemned until his guilt has been established. Hence, the church, in making use of her powers of legislation and coercion, must also exercise judicial power. Excellent. You know, in civil court, they don't have any evidence. There's nothing under seal. No one's swearing to anything. They're just trying to get us to self-confess, and they're going to try to inflict our customs because it's a Roman civil court. In Roman civil court in pagan days, they would inflict the penalty of whatever custom was involved. Right? So they embraced all other forms of courts. So if you came from France to Italy, well, then you were going to be judged by French law. But you would be judged under the Roman system. Well, because we are children of God, they're going to say, well, we're going to judge you as children of God. And when you self-confess, then we can go ahead and render a sentence on you. Now, the fact that we're going to coerce it out of you, we're going to overlook that. This was in accordance to the grave admonition of St. Paul, who urged the faithful not to appear as litigants before civil courts. We are not supposed to be going to a civil court. Don't walk into that private courtroom. If you're looking for justice, it's supposed to be from a canonist, and they better get with it. So this dude furnishes us with the information on this point in these words addressed to the pagans. The church is wont to warn and punish, is a divinely appointed censor whose weighty decisions are accepted as rendered in the presence of God. You bastards better start fearing God. When the Christians attained control over civil power in Rome, the reasons that moved St. Paul to persuade and command the faithful to avoid the civil tribunals were, of course, no longer pertinent, because there was no separation of church and state. When the Christians obtained the control of the civil power, there was just one power. Church and state were unified. Gradually, the church allowed the faithful to submit their differences to either ecclesiastic or civil tribunals. From the beginning of this new era, the bishops shared in the secular magistrates the power of settling the disputes of the faithful. So back in the old days, the bishop and the earl sat together in court, and they judged all the matters. And what's happened since then? Here in America, we've got a constitution that says it's separation of church and state. So the state don't give a shit about the faith. They don't have any jurisdiction, and you're walking into their courts. They don't care if there's any evidence. I'm not living under that. There is no separation of church and state. My church and state are always united. My body is my state, my church is my soul, and they're together all the time. I ain't lost at sea. So what about the faithful? Those who have bound themselves to a religious association whose doctrine they accept and into whose rites they have been initiated. Among Christians, the term is applied to those who have become fully initiated by baptism and are regularly speaking by confirmation. Such have engaged themselves to profess faith in Jesus Christ, from whom they received it as a gift. Henceforth, it will proclaim his teachings and live according to his law. If you've been baptized, you're under the jurisdiction of the ecclesiastic courts. You better be following God's law. You better not be charging your brother, bearing false witness, lying, committing, adulterating my name, coveting my property. Constantine the Great published the two constitutions, 321 and 331, wherein he not only permits laymen to have their cases tried before the bishops, but also decrees that all cases which until then were wont to be tried by a praetorian by the civil law should, when once settled before episcopal courts, be considered as finally adjudicated. It was rightly established, however, that not all cases could be submitted to civil courts, nor could all persons have recourse to them. To decide a controversy, the judge first has to have jurisdiction over matters in question and parties engaged in the controversy. So these these private courts, civil courts, running under old Roman civil law, first of all, they still have to have jurisdiction. And it says, as a layman, you could take your issue to an ecclesiastic court. Now, we've had people who've walked in asking things in the courts of the church, and they've been told, well, that's a civil matter. That ain't working no more. Quit hiding behind it's a civil matter. I want to see signs up in your office that say, for justice, follow the sign, and take me back to the promoter of justice's office. And what about that laity? Having come through baptism to the supernatural life, being members of the Christian society, and adopted children of God, the laity belong to the chosen race, the royal priesthood, foreign to all those who are born again in Christ. So in old Roman law, a private individual, for instance, could hand down a decision. This is in canon law. A private individual, for instance, could not hand down a decision, nor could he compel others to abide by it. In the case of a secular judge, his jurisdiction comes from the civil authority. There is no civil authority. They've all taken ecclesiastic oaths. In purely spiritual matters, the laity is powerless, since God has committed them exclusively to the church. All matters are ecclesiastic matters. All matters are committed exclusively to the church. They put a notary seal on it. Somebody's taken an oath. Those are matters of the church. In this domain, the civil power has neither legislative nor judicial authority. Whatever, therefore, concerns the faith, divine worship, or sacraments of ecclesiastic discipline is foreign to the civil order. They do not have jurisdiction over matters of faith. They have no jurisdiction. Likewise, not all persons are to be judged by secular courts. The church could not permit her clergy to be judged by laymen. It would be utterly unbecoming for a person of superior dignity to submit themselves to the inferiors for a judgment. Well, we were just told we're the chosen race, the royal priesthood. We can't be tried in a civil court. We can only be tried in an ecclesiastic court. If we've already been tried in a civil court, it's a false judgment. However, this is what they're going to use against us, because these private courts that are running under ancient Roman law, the pagan style, where there's a separation of church and state, because they're going to abide by the customs of any other society, are going to say, well, thus, in Christianity, some council condemned the bishop for demanding a civil trial, decreed that clerics who strive to bring lawsuits or disputes before secular judges should be deprived of their clerical dignity and removed from their offices. For maintaining that, at least in temporal matters, a cleric could renounce his right exemption to appear at a secular court. Such action, said Innocent, was unlawful, even when the conflicting parties agreed to submit the matters to civil magistrates. The ecclesiastic exemption was not a personal privilege. It belonged to the entire ecclesiastic body. It could not be renounced by the individual. So they're saying, well, because you came into our civil court voluntarily, You've given up your clerical dignity and you're removed from your office. And we're going to punish you for that with perjury, heresy, whatever one they happen to want to pull out of the penal code. Matters purely spiritual, as explained above, fall within the exclusive jurisdiction of ecclesiastic law. The exclusive jurisdiction, matters purely spiritual, oaths, vows, promises, things under seal of a notary. In addition to these, there were in past and still are cases in which the natural and spiritual elements are so co-joined they take on dramatically another nature and gives rise to different rights. To make this clearer, the author, in addition to the example drawn from certain effects of matrimony, borrows from the ancient Canonist the illustration of a contract entered into by laypersons and confirmed by oath. A banker's taken an oath. An attorney has taken an oath. It's all under ecclesiastic jurisdiction, and they don't have any evidence. They brought a false charge. They've committed contempt of court. Here to the obligation of justice is added that of religion. The obligation of justice. You're obligated to give us justice. Is added to that of religion, and we easily recognize a twofold juridical element bringing the matter in question, at least as far as the value of execution of the contract is concerned, within the ecclesiastic as well as civil domain. They never executed the contract. For a contract to be lawfully executed, both parties must sign it. They never sign a deed of trust. They never sign anything. You don't get anything from them that they've signed. Here, the obligation of justice is added to that religion, and we easily recognize a twofold juridical element, bringing the matter in question, at least as far as the value of the execution of the contract is concerned, within the ecclesiastic as well as civil domain. Where it is a question only of the value of the oath, the matter would, of course, be a purely spiritual one. Well, their oath ain't worth jack if they're not following it, so it's spiritual. In the medieval times, the church exercised jurisdiction in regard to temporal concerns of orphans, widows, and other persons of unfortunate condition. No equitable mind will see therein an usurpation of civil jurisdiction on the part of ecclesiastic authorities. It's your duty. It's your duty to protect orphans, widows, and persons of unfortunate condition. The true and adequate explanation lies in the peculiar necessities of the age, the deficient administration of justice. That's what's happening now, and the undue power exerted by the rich and mighty. Rather, it does rebound to the honor of the church that she then assumed the defense of the poor against the wealthy and the powerful. It's your duty, and your honor is on the line, and came to the aid of those who were deprived of all human help. It must also be mentioned, in the medieval and later, ecclesiastical magistrates were often vested with civil power legitimately acquired because of the church and state being in union, and exercised it not as ecclesiastics, but as civil magistrates. So don't tell me it's a civil matter and you can't do anything about it. You have jurisdiction. I'm one of the laity. Consequently, the first ecclesiastical court is now regularly that of the bishop or his vicar general. Thus, it may often happen that administration of justice in one locality necessitates proceedings in a territory of another judge. But the obligation arises not from the authority of the court requesting assistance, but from the authority of the common law, which so ordains. This is evidently just, for all such courts are courts of one ecclesiastic society, the one Catholic Church, whose welfare demands that in it justice is rightly administered. The notary whose presence was decreed by Innocent is to transcribe with fidelity the acts of the case. Well, guess what? Notaries, again, as the office is merely that of a clerk and does not include any juridical power or jurisdiction, it may be held by ecclesiastic courts, even by a layman. Still, clerics are not excluded from the office. The physical promoter, though perhaps if we attend to the most important part of his office, the better term would be the promoter of justice, is a person who, constituted by ecclesiastic authority, exercises in the ecclesiastic courts and in his own name the office of a public prosecutor, especially in criminal cases. Okay, promoter of justice, you got work to do. There are 4 chief titles by which the accused party comes under the jurisdiction of a certain judge: residence or domicile, contract, situation and object in dispute, place of the crime committed. It is self-evident that in the civil courts it was necessary for the proper administration of justice to place territorial limitations to the exercise of jurisdiction. This is the same restriction which much more necessarily in canon law, since the jurisdiction of the church extends over the entire world. The jurisdiction of the church extends over the entire world. Those of the worldly are under the jurisdiction of the church. So we're bringing these transgressions to you, and we're looking for justice. We are not looking for counseling. You have a duty and obligation. You swore an oath, vow, or promise, and your soul will be damned as a heretic if you do not fulfill the functions of your office. Now, that being said, I know that you will, now that you've been informed. If you have any questions on anything that I've gone over today, don't hesitate to contact me. Rob Ryder, Court of Record, AOL.com. Call me, 616-712-6179. I really hope to hear from you soon. Have a great day. See ya.